Namaskar, Suprabhatam. I am Dr. Vaidhi Pandya from Law College Himatnagar, Gujarat. It is a great pleasure for me to welcome all of you in today's national webinar on importance of fundamental rights in Constitution organized by Himatnagar Kevai Mandal Law College Himatnagar. Let us start our program with a prayer. Thank you very much for the beautiful prayer. Now I would like to invite Dr. Binal Patel, in charge principal of Law College, Himatnagar, for welcome speech.
Good morning, everyone. On behalf of Himatnagar Keloni Mandal, Law College Himatnagar, I heartily welcome our today's speaker, Mr. Chetan Vithlapura, principals and students of other institutes, researchers, and advocates for attending our webinar during this corona pandemic. Your presence is encouraged. Selecting a topic and speaker is a very critical part in event planning. However, our speaker, Mr. Chetan Vithlapara, has made it simple by using his past experience and expertise in this subject. Fundamental rights belong to the human being, just because you are a human being. Again, I heartily welcome all of you. Thank you very much.
Thank you very much, madam. Before we start today's session, we would like to reflect on why this seminar being organized today. All of us are aware of the importance of fundamental rights given to us by the Constitution. Fundamental rights protect the liberties and freedom of citizens against any attack by the state and prevent dictatorial rules in this country. Being lawyers, principals, lecturers of law colleges, and law students, it is very essential for all of you to know and understand the importance of fundamental rights and apply them in your practice. This is the reason we have organized today's webinar for all of you. It is our privilege to have Mr. Chetan Vithalapara, who will be sharing his knowledge and insights on this topic with us. So, the way today's session is structured goes as first we will have keynote speaker speech for 1 hour, followed by another 15 minutes to address your question. Please post your questions in the YouTube chat window. I would also like to highlight that in case of any internet connectivity issues, please be patient and stay on the webinar link while we get back to you. Last and very important, all of you who attend the webinar will receive a certificate of participation on when the webinar ends. Please fill the feedback form from link given in WhatsApp group and YouTube chat box and submit it to receive a certificate. It is my great pleasure to introduce Mr. Chetan Vithalpara, who is your keynote speaker for today. Mr. Chetan is practicing advocate in Supreme Court of India. He holds BSc in chemistry with gold medals, LLB, MSW, BJMC, and LLM in HR. He has served as the head of the department for Sri Sardar Patel Foundation, Rajkot. He faced interviews in the prestigious UPS examination. He has extensively published on law in various ISBN books. He also serves as a visiting guest faculty at Law College Rajkot. Currently, he serves as a panel advocate at Rajkot Nagarik Sahkari Bank. Without wasting any more time, I would like to hand over the session to Mr. Chetan Vithalpara. Cover you to Chetan Rai.
Thank you to all. Good morning, all. Here, Chetan. This is the give my prestigious opportunity to speak before you and sharing my views regarding the fundamental rights importance for every human beings and every Indian citizens. And it's a great pleasure to be share my views all the entire words today's COVID-19 pandemic issues with the technology that is internet technology. That's why we are calling the webinar. So the fundamental rights and human beings. As we know that for every human's needs, in nature we are saying we need the five tattvas, air, waters, it is. And similarly, while you are living in any country, we need some protection from the countryside. So this is entire world's the committee has established and human rights protections. Some laws has been deferred to different country and uh, union states as fundamental rights. It's a very important for the Indian. As we have know, the Constitution, it is a world largest written documents available entire the world, and it is a democratic republic. As just I would like to define the Constitution in single words. You can say it's a supreme law of India. There is a novel law above the Constitution. Constitution is the last law, supreme law. No one law can be made by the parliament, not by the any institution or the an independent. It is a last law supremacy. In the single language, I will define the constitution. It is a legal document. In the legal documents, in earlier, the constitution had some numbers of articles. It's a bunch of articles, we can say. In the earlier than beginning times, in the origin times, and there were Article 395 and Schedule 8 and Part 22. But as the society moves, there must be some changes comes. Society will change, and the parliament, our representatives, our elected members, they are sitting over there and discussing our welfare. So they are time to time changing in the constitution as well. So the currently it's a nearly 448 articles are there and 12 schedules and part 22s. This is the right now, as I would like to say that the last amendment uh, done in the parliament, it is nearly 25th January 2020. It was a 104th amendment. Before this one, uh, I would like to say that what is importance of the fundamental rights in constitution as well as the Indian citizen. I would like to comparison with a human body. Human body, it is made up of the numbers of organs. All organs are important. If the one single organs will fail, the human body cannot work. Like as the heart. Heart is the most important organ of the human body. If the heart is not working properly, it will be disturbed and man or the person can die. Similarly, in constitution or the Indian society, the fundamental rights I compare with the heart. If the fundamental rights, it is not protective or it is not enforceable, then definitely our law entire system, the constitution will be collapsed. In the recently 2019, Justice Arun Mishra and the five-member constitution bench, they have stated that the fundamental rights should be protective. It's the special words that they used. If the constitution will lose the importance of the fundamental rights, then there is no dignities, there is no freedom, there is nothing to the any Indian citizens. So It's a constitution earlier is signature by its nearly 284 members. And as we know that this constitution, it is a, if you see the numbers of books you must read in different concepts, it is a borrowed, copies, all these things. But the constitution, it is a mainly, you can say the concepts. We have taken the numbers of concepts from the other countries to welfare, but it is a molded according to our societies. The honorable and the great man, Dr. Bhimrao Ambedkar, we never forget, Sardar Vallabhbhai Patel's and other juries who have decided, adopted this constitution. They are the more intellectual and more knowledgeable persons. They have taken the concept from the different countries and they have adopted according to our Indian societies. But as I have read, I can conclude that the most two act we are finding in the constitution, it is the Government of India Act 1935 and second the Indian Independence Act 1949. The two act we can see the super seded in the constitution. The most of the parts taken from the Government of India Act 1935 and some but at that time it is modified according to our need and our societies. But fundamental rights, if you see, it is put in the beginning. First, if you see the constitution preambles, second comes part 1, part 2 and part 3. Part 1, union and territories under article 1 to 5, and second it is the citizenships, and third it comes of fundamental rights. It is a more important. So those chapters, those parts were putting before the beginning, in the beginning pages of any books. It is saying something more. It is a more importance. So these fundamental rights is put in the Constitution Part 3. It is Article 12 to 35. Earlier, this fundamental rights it divides in the 7, but right now it is a 6. In the 6, I would like to divide in the difference. It's right to equality. It's Article 14 to 18. Right to freedom. Article 19 to 22. Right against the exploitation. Right Article 23rd and 24. Right to freedom of religion. Article number 25 to 28. Cultural and educational rights. It's a rights of minorities. It's a right to minorities. It's a 29 to 30. And the last, right to constitutional remedies. It's a 32 to 35. This all the articles are too much importance. We have taken this concept from United States of America. It's in USA, it is a Bill of Rights and Judicial Review. This is the concept in USA, Bill of Rights and Judicial Review. Bill of Rights means the USA had a concept like that. There should be a right to each and every citizen of that country. And if these rights are violated by the any government institution, it should be enforceable or it should be approached or it should be justiciable before the court. So this concept we have taken and modified according to our Indian society. So these 6 rights are included in the 12 to 35. But the 7 right was there. It is a right to property. But anyhow, due to the conditions, it was abolished and 44 Amendment Act was passed by the parliament and this is the remote. It is not the right now, but it is a legal. Illegal, it is put in Article 308. Right to property. It is not our fundamental rights, but it's put legal rights in Article number 300A. This is the concepts. Now, one by one, why it's called fundamental rights. There is some reason why it's a fundamental rights. Mulbhut adhikar. There are two rights we find in our constitution. It's a some you can say due to two one. It's a there are constitutional which is giving guarantee to us. It's our rights, our guarantee. The government has to provide. Government must to do. If there is any of rights violation is going on, you can approach the judiciary. It's a duty to the government provide that. It should be enshrined. It should be a justiciable. Second, it is a, all the rights are justiciable. If any rights it is a violating, you can approach to the court. Say for example, if the two students are there in the standard 10th, exam is going on, the both students, the institute examination body has provided the different question papers, means different syllabus, different question papers. If they have done this job, at that time, there is a violation of under Article 14. They can approach to the violation because the same class, same subject, they can change the sequence of question, but not a separate question paper because both are equal before the law. See the article number 14, it's saying that it's a equality right and equal protection of law. You can say it is a right to equality 14 to 18. In this different articles, the fundamental rights providing a protection. No one can bias. You can say right to equality and equal protection of law. This is available to you in the territory of India. Keep in mind, if you are outside the India, you cannot, because there is another country, you cannot ask to implementation of our constitution. But you are residing in India, any part of the Indian territories, you are liable and you are guaranteed by the constitution, you are enjoying these all rights. Same equal protection. The two-person are there. If the trial is going on, same offenses. It's a duty, duty of the institution to have to give equal treatment for each and everyone. No one can bias. This is rights available in government institution, semi-government institution, or any institution where government is providing any grant, granted or any supportive material to that institution. But this is rights is not available in a private institution. At that time, it can be tried by as a, another laws are there. It is available in India. You can ask a legal trial according to that. Right to equality, it's a more importance over rights. Because before few days in Gujarat, you may heard that some one GR cancelled by the Gujarat High Court. It is due to equality. You cannot bias. There is also other another are there discrimination. Other articles are there, but among them, this is the one articles that should be a equality. As we will discuss later on, because in the within times I have to complete the right to equality. In these articles, the numbers of times in past Supreme Courts and the numbers of the different state high courts has given numbers of the tremendous judgment. You can say landmark judgment. Right now, in today's scenario also, Supreme Courts and different high courts, they are giving judgments. In one single verse, I would like to say that the fundamental rights is a life. Court are always using their powers. They are defining this one. Article number 13, it says itself also, the parliament cannot make any law which is violating the constitution part of three fundamental rights. No one can, no parliament, no Vidhan Sabha, no one can make such a law which is violating our rights. It's a protections. You may, in past, the numbers of times Supreme Court has deleted entire acts. Sometimes, also one judgment is that Supreme Court said that if the law is there, it requires some unconstitutional word, unconstitutional sections are there, remove it, and rest of put it. And recently, Right to Freedom of Speech, the Information Technology Act, there is a section 66A revoked. And also, dear all the law students, I would like to say that one Supreme Court judgment, here Vasoda versus Apple something, judgment 2019. It's a judgment said that in the Domestic Violence Act 2005, the section 2Q, there's a word, it is a written, it is a male. The Supreme Court bench has deleted these words, male. Instead of that one, they put a person words. See, entire act has not cancelled or not revoked, not a null and void. But this person, Supreme Court held that this man words, it is a violating the fundamental rights, right to equality. So they have replaced this word by the word of person. It's a too much importance as a lawyer or as a law students. Earlier, it was just a case filed by the women only, against her husband and her relatives under the domestic violence. But the Supreme Court has changed. This is the only one single right, the right to equality. They put towards person. It means, really, we can interpret that man can also file. If there's such cruelty practice, or you can say he is a suffering from this, they can also approach to the judicial process also, legal rights. The next, it comes article number 15, the non-discrimination on the ground religion, race, sex, caste, or place of birth. These articles, it's a very important in the beginning times of the Indian independence. At that time, there was a discrimination was carried out. But right now, I think there is no much more we have seen. But this rights, it's available till also. No one can discriminate on the basis of the religion, in which religion you are belong to. All are equal. That's why we are secular. Race, caste, from which caste you are belonging, sex, and place of birth, from where you are coming. So this is not that much right now. It is currently in issues or Indian constitution or today's scenarios. And second, it's a equality of opportunity in public employment. This nowadays the Supreme Courts or the numbers of courts, they are giving such protection. As today's in the job, the Gujarat High Court has cancelled the one GR. You can say it is the equality of opportunity in public employment. We can say that Gujarat High Court also taken this article in consideration. All have equal opportunity in job, in public employment, in the government job. You cannot bias on the basis of caste, sex, race, or any other in under Article 15. All have equal rights. So you can read the High Court judgment regarding this, and also High Court has given the guideline how to modify the result. It is also given, and they have given some guideline. You can proceed this recruitment according to this guideline also. And next article is the 17. We are just going to briefly. It's the abolition of untouchability. It's why this is quoted because at the time there was our different system, monarchy system. Then we became a independent democratic republic. So it was a necessary to malafide practice by the peoples, and they are the all the peoples. They are keeping distance from the certain classes or persons or certain caste. It should not be there anyhow. All are respected. All are the children of the Bharat Mata, and we all are binding to follow the constitution. It is very important. And next article it is 18, abolition of titles. This concept why it is required because the before the independence, the British government they were providing uh, let's say best knowledgeable persons and you can say kings, rajas, maharajas. They are providing the titles, sir, some other titles also. So it is a discriminated. If the one person it is coming who are holding such a title, sure, it is superior. The Indian citizen they are feeling that he is above me. So it is the concepts is taken. If this title will remove, so all become equals. Right now, it is not available in India. But at that time, we have to keep in mind that you can also hold the title of education, which you got from the education. Say, for example, if you have a clear the MBBS or any medical degree, you can use prefix doctor. You can keep these titles. It's educational titles. Similarly, if you are in armies, if you are holding any rank, army title, brigadier, colonel, major, major general, any this title you can hold. It is your duty titles as well as the educational titles. So next, it is our second right to freedom, Article 19 to 22, right to freedom. This articles, it is a very important articles. Right to freedom, it means that recently the high courts and other courts, or the last you can see the judgment has delivered by the different benches. They have taken these rights. As I told you earlier, the Supreme Court has revoked the Section 66A. If you put your ideas or you are sharing your ideas on the internet or any electronic media, before it, the action was taken by the police or any institute on this bad violation of 66A. But it is expressed, this is section, it is a violating our fundamental rights. It is under Article 19, right to speech, right to express uh, our views. So it is revoked. It is a consults. So just under Article 19, the importance it is a freedom of speech. Everyone can speak anything, but keep in mind it should not be a harm to anyone. You have right to speech. You can speak, but it should be in legal manner. It should not be a harm to other person. It should not be a disturbed for law and order. In such manner, you can share. If you're using a wrong language or you are using such words, such speech, which are disturbing law and order of societies, the peace of the society, at a time, the government or the regarding institute can take action as a law which is enforceable in that time. So this right is available, but not to sake of the welfare of societies. Freedom of expression. You can you can express. Similarly, it should not be a disturb to other citizens because whatever rights we have available, all the rights are available to other Indian also. They are enjoying same rights. Next one, freedom of assembly without arms. We can enjoy to make assembly with peacefully. Here the words without arms. It is too much importance. If you are going with arms, it is giving clearly indication that you are going to disturb the peace. You are violating the law and orders. At that time, the regarding institute can take action against you. This is our fundamental rights. You can assemble, you can make a group for the welfare of society, for the peace. You can say in the manner of the Mahatma Gandhi. But keep in mind, law and order must not be disturbed. At the time, the one question can be arised with the Jaharnama we are saying. Regarding any district magistrate or sub-division magistrate or executive magistrate or any commissioner has announced any Jaharnama, public informations, you cannot make up 4 or more persons. At that time, can we enjoy this one? Yes, we can enjoy. But keep in mind, the circular which is issued by the authorized person, it is issued for the sake of law and order, for the welfare of Indian. It should be follow the guideline, and we can. It's a better way. We approach to the circular authorized person and take permission from them. We have a rights. It's a peacefully because whatever action he has taken, it's also in consideration of law and as well as the constitution and our fundamental rights. But it is necessary to issue such circulars. We have to take in consideration also freedom of association, practice, freedom of practice any profession. You can practice any profession in India, anywhere, any part of the country. But these articles should be properly understood and interpreted. It is single words, freedom of practice of any profession. First, I will to more clearly to you. Any profession. समझ लो मैं कोई केले की लारी चला रहा हूँ. It's my profession, selling of banana. If there is one cross is there. 4 roads are joining one places. It's my freedom to practice any profession. If I will take one lari, put cart, and I put in the center of the road, and I will say that it's my fundamental rights, right to profession, right to profession of practice of any profession. It's your rights. But if you are standing or selling for bananas, you are standing at the center of joining of all roads. It is a disturbing the traffic rules, law and orders. Whatever you have a rights, same rights are available. All are passing from roads also, or all are passing from by car, by cycles, by motorcycles, whatever they have a transportation machinery. They have that rights. Here, your rights is available, but according to easily availability to the purchaser, not disturb to the any person, and first law and order, because law and order is created for our welfare only, not for the government. Government, we are government. So this is right to practice. It's any profession, but keep in mind this is not available to you. Sometimes You must read in newspapers or anybody else, Ladi Gallavara and Nagar Palikas, Mahanagar Palikas, they have demolished all these things and they have taken the Ladi Gallas and put fines, all these things. Yes, because in the Menka Gandhi cases, later we will discuss, the Supreme Courts and have dealt with the entire things. That the numbers of rights, the Supreme Court has derived the A to Z over rights. If these are the selling on the roads, where will you run? Where will you drive? Driving is the safety. If this will be too much consecutive, accident may be happen. So this practice is available, but according to a law. But this is the all the laws they are made according to constitutions, fundamental rights. When and where these laws are constructed at that time, the drafting bill, the government are asking to share your views to the regarding the ministry. You can share like as Lokpal and different bills has passed in the past or in the future. They will give information in newspapers and PIB in everywhere. If you have some views, you can say to the government because ultimately laws are made up for making for us only. We have a right to share views. Or also we can share by emailing also, writing a postcards of things. They are giving advertisement. They are asking our views. After that word, so they are the expert are available to making such law. They are keeping all these things in mind. Even though some errors are there, some unconstitutional portion are there. If you are finding till that the act already passed in the past, but till there is a Supreme Court has a power judiciary review, we can approach respected high courts as well as direct to the Supreme Court. If the courts judicially find there is an unconstitutional portion, they are removing such portions and making law for the welfare of societies. Why it is too much important? Because fundamental rights, it is the backbone of country. It is a, while in human body, if you are standing straight, we are walking, and we are presenting our personality before any person because our backbone is strong. If backbone is not strong, then you cannot stand. Similarly, if backbone fundamental is not strong, our country collapse. It cannot stand in any situations. Right now, countries are passing. It's a COVID-19 issues, something issue as borders. We needs our backbone strong, and you can say it is a self fundamental right, the self guardian of the people's interest. All the rights, it is a made up for interest of people only. All the citizens who are comes in the citizen, there is citizenship act is there, and also the part two is there. Why belong to the citizen? But it is available to all. It is a safeguard, completely safeguard. One, I would like to say that in the COVID-19, there is some issue came out from different hospitals. The government has taken the serious point and concerned ministers as well as the chief minister has taken visit their places and given the one essential orders to them because in Article 21 in mental Gandhi cases, right to health, it is our fundamental rights. That's why The Indian government as well as the other state governments, they are taking steps to cure or taking the health as a priority to each and every person's. The test of the COVID-19, giving notifications, circulars, to giving advice to the each and every citizens. Keep a distance, wear a mask. If you are going in a public places or you are going from outsides, if you are single, there is a no need. But keep a precaution. This is the entire world is suffering from COVID-19 issues. Fundamental rights is there. That's why our Honorable Secretary for the Health Department, center and states, as well as the local areas, they are every day they're announcing or taking notes or the report on the respected area. This is importance, right to health. And second, the most, it's a judicial review. This concept also came from the USA under 13. Supreme Court has a superior power for the any act which is passed by the parliament to give a judicial review. We will say in different parts. Before just we go for the some different judgment, I just complete this another Article 20, 20 and 21, the protection in the respect of the conviction for the offences, and 21, protection of life and personal liberty. This is Article number 21. Right now, in today's scenario, today's condition, it is very important. Article number 21, right to liberty. You can say protection of life. We were discussed in the Manka Gandhi cases. And 2030, right against the exploitations. As we know that labor child labor and human trafficking. No one can exploit social. Nobody can exploit you. If something it is going on, you can approach respected judiciary institution, high courts or Supreme Court's direct also. And 25 to 28, right of freedom of religion. This is concept of seculars. If you see the preamble, it is already written. Brotherhoods, secularism, sovereignty, democratic republic. These concepts as a preamble, it is a, you can say short, briefly, short, it is defined, this is the constitution. So the you can practice any religion as you wish. But this religion should not be adopted by forcefully. It should be by your wishes only. Any religion you can practice. You can go any religion class. You have a right. Practice, worship is your fundamental constitutional rights. Next, it is a 29 to 30. Right to minorities, cultural and educational rights. You know, India, there is a diversified cultures. If you visit each and every corners, you are finding the different cultures, tremendous cultures. All are unique and their nature only. If you see the Jammu and Kashmir, different cultures. You come down Punjab, Haryana, Rajasthan, Gujarat, Maharashtra, Karnataka, Kerala, Madhya Pradesh, Chhattisgarh, West Bengal, everywhere. In West Bengal, they get Chhat Pujas. They are celebrating. It's a why, and you can say huge people are taking parts. In Gujarat, Navratri, longest. In South India, North India, they are the unique in their cultures. Their habitat are unique. All are joining with their culture, and all have their also educational rights. They can spread the minority. They can enhance their educations. That's why we are finding some minorities institutions, special safeguards to survive their culture. They are in minorities in numbers. If any big attack on them, their survival comes on question. There is a difficulty to survive their cultures and education. For that why the fundamental rights provide to safeguard them. You can enhance your culture. You can spread your cultures by the way of education. You can save yours. Next, it is a 32 to 35. Right to constitutional remedies. It is to it's a very importance. Very importance. We have discussed entire things. Article 12 to this is a 30, 31 till 32 to 35. The question should become, so we are getting all this and we know this all are the rights and from where you are saying the high courts and supreme courts we can approach, but how and which act, which articles should we approach? What is the procedures? Remedies, what are the remedies? Remedies are elaborate in these articles 32 to 35. It is you can say the article 32 to 35 and also along with read with article number 13. There is a under article 32, if any fundamental rights is violating, it is a, whether it is individually or whatever, but it's your rights and any government institution is violating you, you can directly approach to the Supreme Court. Supreme Court take seriousness and issues the writs. Habeas corpus, mandamus, all are there. If you want to wish not to approach to the Supreme Court direct, you can also approach your respected state high courts. Under Article 226, they are taking consideration and also is issue the writs. Whatever power High Court, same power as Supreme. Supreme Court power has a High Court, same power. But if the manner of the writs, the High Court has a more power than the Supreme Courts. Because it is available in local areas. It can easily entertain. It's a long discussion how why it is a difference of power Supreme Court and High Courts in the manner of the 2 to 6. At that time, the Supreme Court and High Courts, they are taking judiciary review. What are the errors are there? Does it have any unconstitutional part? If it is there, how it can be cured? The Supreme Court delivered the judgment. If it is required, the null and void, the Supreme Court and High Courts declared as a null and void. If it is required only that cures some part and remain as it is, it means that some portion are there, it is unconstitutional. but rest of are constitutional. At that time, the Supreme Court or High Court, they are removed just the unconstitutional parts and keep the constitutional parts as it is. As we have seen the in Information Technology Act only 66A and also in Domestic Violence Act Section 2Q, the word male is replaced by the person. So this is the fundamental rights. But in the cases, there's some important cases we have to study also. Under Article 30, the Supreme Court has a power to do the judicial review. Judicial review is any act passed by any legislative assembly, whether it is a Lok Sabha, Rajya Sabha, or any state assembly. They are making any act or passed any act in their assembly. The act, if it is unconstitutional, at the time, the court has a power to do the judicial review. Certain cases, some few cases we are taking right now in discussion. One is the Sajjan Singh case, 1965. You can say this era, 1965 to 1918. It is, you can say, in my language, it is a fighting between supremacy of power. Whether Parliament it is the superior, or the Supreme Court is the superior. There is a tough fight was carried out in this time periods. In this time period, the Supreme Court has delivered the numbers of tremendous landmark judgment to survive our the democracy and safeguard to Indian citizens. Sajjan Singh, in the cases, Supreme Court held that the Parliament can amend any part of Constitution, including the fundamental rights. See, in the Sajjan Singh cases, 1965, the Supreme Court held Parliament has a power to amend any part of the Constitution, including the fundamental rights. But after this time period, there was a Goloknath case. Goloknath case, it's a Goloknath case versus state of Punjab. It's a 1967. After the 2 years, what was judgment was delivered in the Sajjan Singh case. It is a reversed. The Parliament have a power to make a changes in Constitution, but fundamental rights cannot be amended. See, this is the Goloknath cases. You can show it is some land related cases is there. In this cases, what was the situation was there? It was the Goloknath. It is one of the family who holding some lands, and Punjab government has make up one act. It is a, you can say, land related act is that it is abolished. You cannot violating or you cannot amend in the fundamental rights. This is the landmark judgment, Goloknath. What happened after this? In the Goloknath cases, and Supreme Court taken the 3 articles seriously. Article number 14, article number 19F, and article number 19G. And Supreme Court entertained these cases, these matters under Article 32, Constitutional Remedies, Judicial Review. You can say in the Sajjan Singh, what held the Supreme Court, Parliament can amend any part of the Constitution, including the fundamental rights. Before this one, the one act, it was the act Punjab Land Security Act 1953 and Mysore Land Reform Act. Two act was taken. The validity of this act in the Golaknath cases. Golaknath is one family. In this cases, family, the government has taken land deeds because they are holding a more lands. Taken lands and distribute to the other peoples to welfare or improvement of the people, other people. There was a good wishes by the government, but Supreme Court observed that it is a violating of fundamental rights. At that time, right of property was a part of the fundamental rights. In these cases, under Articles 13, the Supreme Court taken a judicial review of these two acts. One is the Punjab Land Security Act 1953, Mysore Land Reform Act. And this act declared null and void. And Supreme Court has clearly said that Parliament cannot touch a fundamental rights. It means Parliament cannot make any amendment in the fundamental rights. So, Article number 368, it is defined the amendment procedure in the Constitution. Under 368 articles, Supreme Court read with under Article 368 and under Article 13. Under 368, Parliament cannot make any changes. And Article 13, Supreme Court has a power to make a judicial review. अब तो समझ लो पार्लियामेंट और सुप्रीम कोर्ट के बीच में फाइटिंग अच्छी चल रही थी. सत्ता तो किसके पास थी? पार्लियामेंट के पास. What they did? They have passed the 24th Amendment Act, 1971. 1971, 24th Amendment Act passed and declared that Parliament has the power to amend anything, including Article 13 under the procedure of under Article 368. समझ लीजिए सज्जन सिंह ने क्या बोला था. सज्जन सिंह वाले केस में सुप्रीम कोर्ट ने आप कुछ भी अमेंडमेंट कर देते हो, कर सकते हो. गोरखनाथ में दो एक्ट नल एंड वोइड कर दिया. बोला क्या फंडामेंटल राइट्स को अमेंडमेंट नहीं कर सकते. इवन यू कांट टच इट. अभी तो सिर पे आ गया. पार्लियामेंट में मेजोरिटी थी. मेजोरिटी के साथ पार्लियामेंट ने 24 अमेंडमेंट एक्ट पास कर दिया 1971. अब तो सुप्रीम कोर्ट तो वेट ही कर रहा था, कोई तो आए मेरे पास. फेवर वेटिंग. इसमें अभी थोड़े दिनों पहले ही एक फेमस केस है और दिस केस हैज चेंज्ड द एंटायर डेमोक्रेसी एंड ऑल्सो दे प्रोटेक्ट फ्रॉम द डेमोक्रेसी. हमें आजाद रखा, डेमोक्रेटिक कंट्री बने रखा. केशवानंद भारती वर्सेस स्टेट ऑफ केरला. इसमें दो लोग थे. एक एडवोकेट नाना भाई पालखीवाला, थोड़े दिनों पहले ही वो भी हमारे बीच नहीं रहे. You can say one of the top most advocate, and who fought this case on behalf of the केशवानंद भारती. अभी जो संत थे तो वहां के हिज होलीनेस स्वामी केशवानंदा वो एडमिन मत के संत थे. केरला की मठ है. उसमें क्या था, उसका मंदिर है. मंदिर की थोड़ी सी जगह थी तो केरला गवर्नमेंट ने एक पास कर दिया, वी विल हैंड और वी विल टेकिंग ऑल द केस ऑल द प्रोसीजर. वो पूरा का पूरा जो उसका एडमिनिस्ट्रेशन है वो लेना चाहते थे. इट्स अ वायोलेटिंग constitutional rights under Article 26. It is a violation. So Nana Bhai Palkhiwala, he appointed as advocate on behalf of the Swami Keshananda. You must read in newspapers as well as if you are connected with social medias. Swami Krishna, I think before last week, he passed away, and before few days, the one of the most famous and one of the best advocate, Nanabhai Palkhiwala, he passed away. In this cases, क्योंकि जो गवर्नमेंट ने जो 24 अमेंडमेंट एक पास किया है, सुप्रीम कोर्ट तो वेट ही कर रहा था, कोई तो आएगा मेरे पास, बिकॉज द सुप्रीम कोर्ट he is the safeguard of constitution. He is the, you can say, giving the protection, working as a protector of the constitution. अब एक टाइम हो ही रहा था 1971 में सरकार ने एक्ट पास कर दिया. अब घड़ी आई थी 1973 के स्वानंद भारती, नाना साहब पालखीवाला ने, but it is a violation of these cases. तो केशवानंद भारती डायरेक्ट अप्रोच टू द सुप्रीम कोर्ट. जो सुप्रीम कोर्ट इंतजार कर रहा था, कोई तो आएगा. In these cases, the Supreme Court held one tremendous judgment. सुप्रीम कोर्ट ने बोला चलो सज्जन सिंह ने केस में जो सुप्रीम कोर्ट ने जजमेंट दिया ठीक है, गोलकनाथ में जो दिया थी आप टच नहीं कर सकते, चलो आप टच भी कर सकते हो, you can amendment, but you cannot change the basic structure of the constitution. It means आप कान ऐसे पकड़ोगे या ऐसे पकड़ोगे, पकड़ना तो कान को ही है. And basic structure defined by the Supreme Court also. जैसे प्रियम्बल में लिखा है राइट टू जस्टिस, पूरा का पूरा लिखा है. Basic structure, all the fundamental rights are including. It is a giving a safeguard. You cannot disturb the basic structure. You cannot destroy the basic structure. And one more, Supreme Court has a power to do any act which is passed by the parliament or any legislative assembly to do the judicial review. आप कोई भी एक प्रसार करोगे, सुप्रीम कोर्ट तो उस पर जुडिशियल रिव्यू करेगा ही. If it is unconstitutional, Supreme Court or High Court declare it unconstitutional and it declared as a null and void. And this rights, this preamble, it is not a part of the constitution. Until that, this judgment, it is available. We are enjoying this judgment. Till, that's why the Supreme Court has 66A, other Domestic Violence Act, Section 2A or 2Q. It is this portion declared as unconstitutional. Due to this one judiciary review, under Article 13, Supreme Court has a power to this one. After the passing these times, one more judgment is delivered by the Supreme Court. आप मेनका गांधी को सब जानते होंगे. मेनका गांधी वर्सेस यूनियन ऑफ इंडिया, साल थी 1978. उसमें क्या था, मेनका गांधी का जो पासपोर्ट था वो सरकार ने इंपाउंडिंग कर दिया. उस टाइम पे जो पासपोर्ट एक्ट थी, इट वाज चैलेंज्ड. मेनका गांधी अप्रोच्ड सुप्रीम कोर्ट डायरेक्टली. Violation of our fundamental rights, Article 19 and Article 21. Right to liberty. It's my rights. Right to live as my wishes, right to liberty, right to free. It's my rights. Government cannot impounding my passport. That should be a proper reason. We are human. We have a human rights. And due to that one, the fundamental rights is provided in the Constitution. So the Article 21, earlier it was in the 2 to 3 lines only. But in Manka Gandhi versus Union of India, cases 1978, Supreme Court has described, or you can say, elaborate the act, entire act. It is a very important right to freedom, right to, you can say, right to health, right to uh, clean and healthy environment, all the right to information, right to educations, all are the rights. Article 21A, it is added up to this on base of this only. Numbers of protection against the handcuffings. It is A to Z are there. In COVID-19, the government are taking serious notes on situations each and every minutes, each and every days, and declaring some modifications due to right to health, right to information. We are asking any information from any government institution, semi-government institution, or any institution where they are getting granted from the government. Right to educations, children 6 to 14, free legal free education, 18 age 6 to 14. This is our rights. You must see the Supreme Court, High Court. They have in the past of BS4, Supreme Court has announced or the stop the production of BS3 automobiles or any motorcycle, any vehicles due to its fundamental rights, right to clean environment. Or you must say that your last times you must read in newspaper. The Supreme Court or the Delhi High Courts announced there is a stopping of the industries which is working carrying out production in Delhi areas, and also give the guideline to nearest states, Haryana, Punjab, to do not burn the crops because the movement of air it will come on the cloud of the Delhi area. There are the problems for breathing. Or you must read in newspaper or any TV news channels. There is a holidays in schools, holidays for childrens, and there is a red alerts. This is a range of pollution is raised and providing the some advisory respected governments, and also government or courts they are advised to do bicycling to protect from the pollutions. This is right to clean environment. These are the certain. You read it the entire A to Z. It is defined. Each and every one. Supreme Court has taken over single necessity, single single point as elaborate under Article 21. You can meet. You can take before your. You can say if there is a your investigation, police custody is there. You can approach to any advocate. It's your rights. You can take advice. CRPC under section 41D, you can take advice from your legal advisors and advocates, whatever you have appointed. Number shops. Or right now, the Supreme Court, you must read some news. The Supreme Court has taken helmet issues. It's a right to life. Right to life, it's our fundamental rights. That's why, if suicide, it is a crime. If you're doing the suicides, the legal action can be taken against you. Because the Constitution it is a providing to you right to life, not to die. Government is guaranteed to provide to right to life. If you're doing the suicides, it is a legal crime under the law. You have to live with a fully dignities, liberties. Your choice is under your fundamental rights and under your wishes. This is the important judgments. Second one, last two judgments are there. It is after 1978, Minerva Mills Limited versus the Union of India, 1980. This judgment came on one, you can say, act. The government has passed. ये टाइम पीरियड कौन सा था? टेक्सटाइल जो इंडस्ट्रीज थी वो बीमारी हालत में चल रही थी. They were not working properly. So what happened? The government has passed the one act, the Sixth Textile Understanding Nationalization Act 1974. उसमें जो कंपनी जो है प्रॉफिट नहीं कर रही है या नहीं चल रही है, तो they have taken power on them. Minerva Mills, they approached the Union of India, and definitely the Supreme Court must take as a judicial review. पूरा का पूरा एक्ट उसने जुडिशियल रिव्यू में ले लिया अंडर आर्टिकल 13, and this act declared null and void. And last, you can say one of the most important, which are the other parts also taken in consideration. It is SR Bombay versus Union of India, 1994. SR Bombay, he was the citizen of India and he was residing in Karnataka. A time period आप देख लो 1994, there was an emergency in the state Karnataka. President's rules थे. He approached Supreme Court and he argued that the president's rules was imposed in the Karnataka state under Article 356. It is unconstitutional. It is a disturbing the structure of federalism. India, it is a quasi-federal. Unitary, you can find some articles are there. It is a defined the unitaries. Some are the state also act either independent also. Quasi-federal, we can say it. Not like as America. It is a completely federal. It is a quasi-federal. The federal structure, the federal character of constitution, it is a disturbing. So Supreme Court has taken the consideration and do the judicial reviews. What are portion are unconstitutional. So Supreme Court said that if you are imposing any emergency at a state level, it should not be a malified intention. You cannot impose emergency on the basis of failure of the administration mechanism. You can say one Sarkariya Commission, what they submitted and their submission, it is a more similar to this judgment. Sarkariya Commission. You cannot impose state emergency on the basis of failure of administrative mechanism. There should be a proper reason, and this reason should be satisfied. It should not be a malified intention anyhow, any manner. So judicial reviews point out the 3 points. It is there any material behind the proclamation of emergency? 3 question answerable होने चाहिए. पहला, कोई reason है material? It is imposing. कोई proper reason which can be a justiciable. Second, if there is a material, does it relevant this situation? मटेरियल कोई है, क्या वो उस परिस्थिति के रिलेवेंट है या विपरीत है? It should be taken Supreme Court in these cases. Thus, was there any malified practice? सुप्रीम कोर्ट के केस में तीन लिया, तीन कंडीशन उन लोगों ने स्टडी की. फर्स्ट, behind any material, relevant or malified practice. After this one, they have provided the guideline, and this is the you can say such way I can conclude in the short sentences the fundamental rights in our Indian law societies. It is like as oxygen, like as a hemoglobin, like as a heart. If heart is not properly working, the human body cannot work. It can be disturbed. If it is not properly self-guided, then human body completely destroyed. Similarly, if there is a fundamental rights, it is not protected. The one sentence Supreme Court Arun Misal cases, I earlier said that five judges constitutional bed that if there is a constitution will lose the importance of fundamental rights, then there is a nothing. It should be a protected. So all the rights we are enjoying. This portion it is a lengthy and it is a lots of judgment has been derived by the numbers of times in a single articles the numbers of judgments are there. Article 14 have a 5 to 6 judgment. Article 15 there was a it is added in the one you can say article 15 article 15 4 was 15 clause 4 added in one judgment. It is the state of Madras. It is a Champakalam Doirajan versus state of Madras for the reservation. So the its articles itself has a numbers of judgment. It is a lengthy discussions, but I try to explain in my short way, in my best way. If you have any doubt regarding today's discussions, you can put a message to me so I can trying to answer to you. You can put a message in chat so I can reply to you. So you can say the authorized person.
Thank you very much, sir. The Constitution
Thank you.
for all citizens, individually and collectively, some basic freedom in the form of six broad fundamental categories of fundamental rights. Sir, you have highlighted all fundamental rights broadly. Again, thank you very much for this enlightening session today. I'm sure you all of our audience have been benefited from your knowledge and experience. Without wasting
Uh,
any more time, I would like to
ma-
proceed with the question answer session. I hope you have already put it, your questions and queries. We will try our best to answer as many questions possible and would like to apologize if any of your questions are left due to the time constraints. I would like to request Mr. Chetan Vikhrapara to kindly address the questions. Sir, please.
yes, just I'm checking it whether any questions is coming. Mm, I think one question comes from the Bhavesh is સર શું આપનું ફંડામેન્ટલ યુએસએ માંથી કોપી કરેલ છે? Yes, dear Bhavesh, I think you are coming from the law students, law backgrounds. Is the constitution of India, it is not copied from the any country, not copied from the USA, but the concepts of fundamental rights is taken from the USA and it is described and drafted as our Indian societies. As earlier I have discussed that the concept of right bills of rights, and the judicial review. It is taken from the USA concepts. But at that time, I have to give the one judgment. In the USA, the Supreme Court of USA, there was a one case is the Marbury versus Madison. It is the USA Supreme Court held that the concept of the judiciary review. There was a bill was rights, bill of rights, and the cases in USA. The Supreme Court held that USA Supreme Court. It is a Marbury versus Madison. The judicial concept given by the USA Supreme Courts. But same was held in India also. You can say the Marbury versus Madison cases in for USA. So in India, it is L. Chandra Kumar versus Union of India. Judiciary review. In the USA courts, it defines judiciary review. In Indian Supreme Court held said that the under Article 32, Supreme Court has a power to do the judicial review, as well as under Article 2 to 6, the High Court, respected High Courts of respected state has a power to do the judicial review. The case was N. Chandra Kumar versus Union of India. I think you can understand. And just uh, just I'm checking the just right to the case was one question is there. P.S. Puspa Kumar, I feel right to get the maintenance should be included in the fundamental rights so that the maintenance and the divorce may reduce. And it want to your opinion on the same. Sorry, the right to maintenance, it's a matter of the family issues. It cannot comes for the each and every rights because these rights are available for independence. It's in each and every one's individual can enjoy. But right to maintenance cannot enjoyed by the each and every. It is already defined in the different laws and the CRPC under Article 125, Domestic Violence Act, Hindu Marriage Acts. These are the already defined. I think no, I don't think so. It should be put in the fundamental rights. But right now I can't say anything because I don't have any power to be put in the fundamental rights. But in future, if the situation maybe comes and our honorable parliaments they feel that it should be need added as a fundamental rights, they can. But I cannot say more than. But it is a you can say legal rights are there. Legal you can go as a legal process also. You can get uh, maintenance as a law, which is required because it is a matter of evidence. So it should not be this one. And one more question, can I got if right to create a lawful assembly is illegal, then why in the case of it is the Syrian Karim, if right to create a lawful assembly is the legal, then why is case of 144 why it is not legal? My brother, it showed as I defined that right to assembly without arms. But at that time, I also explained that this assembly should be arranged without violation law and order. The district magistrate, sub-division magistrate, or executive magistrates has a power to maintain. It's a duty of that person to maintain a law and order. If he is feeling that due to this assembly, then law and order may be disturbed, it may be harm the environment or peaceness of that area, they put some restriction on that one. It's a duty of that officers or its authority. So it may not be put in the, you cannot interpret as a fundamental rights. And one more questions which I need answerable. I will trying to. One question I got from the Anu Sharma. Respected sir, my question is why don't we impose any punishment on social media freedom regarding the implement in the curbing the spread of the hate speeches online through the same light on this one. Uh, Dear law students, there is a law also. You must read it. There is the if you are giving hate speeches or the whatever manner, there are these certain laws are there in the IPCs, also other act which is also created by the respected states, and also some are there if it is a violating to the harmony of India. There is a also sections laws are there that it must be a action taken by the respected institutional police that they are taking in consideration. They are taking legal action against them. It is already is there, but for this one I think you need some study regarding that one. But you can speech, fundamental rights provide you speech, but it should not be harm to other. Legal action are already taken. You just go through some study, legal study. Just I got also what is violated fundamental. Any question, Mr. Senior Surveyor? It's a High Court પાસે કે સુપ્રીમ કોર્ટ પાસે એક્ટ સિવાયના કોઈ પણ ઓર્ડિનન્સ કે અન્ય હુકમ રદ કરી શકે છે. Yes, Mr. Senior Surveyor, High Court under Article 226 and Supreme Court under Article 32 has a power to declare null and any null and void any act, ordinance, GR or any circular. Are you getting me? कोई भी चाहे वो एक्ट हो, ऑर्डिनेंस हो, जीआर हो, सर्कुलर हो, अगर वो कॉन्स्टिट्यूशन के खिलाफ है, it is a violating our rights. At that time, Supreme Court or the High Court, Supreme Court under Article 32 and under Article 226, High Court can declare null and void. And recently, Gujarat High Court has declared make a changes in the one GR also. It's a, yes, they have a superior power under Article 13 as a judiciary review. Ekta Dave, it is a, what is the meant by the term of the constitution? Constitution, it is a legal written bunch of laws, bunch of act. Simple, it is a legal documents. It is a, those who have any doubts, they can ask what are the. Those questions, those who want to, they can. I think there is a. Neha Goswami, she asked one question. Hello, respected sir. What if the media violate the fundamental rights? Is there any right against the media? As nowadays, media trial is going on in the most of the cases. Madam, this is a media, you can say it is a third pillar of our democracy. If there is a violating individually, if the media it is providing the wrong or incomplete or the without taking complete information, they are going to trial, they can also face the uh, uh, legal action against them. But you have to keep in mind that this law, it is a subject of interpretation of word. What kind of words they are using? Keep in mind. Generally, they are using. We are getting from our secret sources. जानकारी के अनुसार they are using such words. They are not saying the fixed words. If you must read that some medias they are also facing some prior FIRs against them, it can be there is a legal action against them also. But we never forget that media is a third pillar of our democracy. Never forget it. So whatever hide by some criminals, it is opened by the media also. So whatever language they are using in the media trial, it should be taking in consideration what word exactly they are using. If you are feeling that it is a violating, then you can approach High Court or Supreme Courts. I think there is no other question required to the answer. All are the simple questions. So I request to the organizers, they can proceed.
Thank you very much, sir, for this question answer session. I would like to extend thanks and gratitude to our keynote speaker for sparing his valuable time and sharing his views. Now, I would like to invite Dr. Paras Joshi for vote of thanks.
I thank everyone who have given their presence in the online national webinar. On the behalf of all colleges, I thank today's speaker, Mr. Chetan Vitlapara, for giving us his prestigious time and sharing his knowledge. I would like to also thank all of the principals, students, teachers, law experts, and advocates due to whose support we succeed in this webinar. We thank the President, Secretary, and all the members of Himatnagar Keloni Mandal. At last, I would thank our college staff and students. I would especially like to that Suk Patel for providing us technical support. Thank you very much. Jai Hind.
Thank you very much. Now I declare the session officially closed. Thank you very much.